including using official power, Congress has specifically prohibited witness tampering. Trump has done that several times. Action 1512C1 specifically includes the requirement that the defendant act with the intent to impair the object's integrity or availability for use in an official proceeding. A requirement that Congress also included in two other sections of 1512, B2 and B. Use of intimidation, threats, corrupt persuasion, or misleading conduct with intent to cause a person to destroy an object with the intent to impair the integrity or availability of the object for use in an official proceeding. To appear before Congress in an obstruction of justice case, the person does not need to have corrupt intent. He or she merely must intend to impair a proceeding. Congress acted deliberately when they looked at conduct, section 1512C2, addressing conduct specifically, obstructing, influencing, or impeding a procedure. The purpose of mentioning these actions of law is clarification. In sections 1512C1 versus 1513C2, they are co-equal when determining conduct. Destruction of physical evidence with intent to impair, as well as conduct that intends to impair a proceeding. If you do both, that's worse. But one or the other is appropriate for Congress to proceed with the obstruction of justice case. 1512C2, therefore, the courts have broadly defined obstruction and look at obstruction in any form. The president's conduct personally took many forms, from personal insults to praise, to using social media, to using surrogates to carry out his dirty work, to going to the newspapers. Though he calls them enemies of the people, he has no problem using newspapers when he wants to subvert justice. Trump uses the printed press or TV to get his message out. Section 1512C2 can be used against AG Barr and Treasury Secretary Steven Mnuchin, as well for conduct that impedes, obstructs, or influences any official proceeding. 1513C2 has been used in the courts and upheld convictions for conduct that thwarted investigations or arrests, whereas C1 is used for conduct that impairs the availability or integrity of documents or records. The other basis for impeachment under obstruction of justice or high crimes and misdemeanors relates to tipping off the people being investigated, thereby hampering the grand jury process. Therefore, 1512C2 refers to corrupt acts, including public officials, that threaten the commencement or conduct of a proceeding, and not just the acts that makes evidence unavailable or impair the integrity of a proceeding. These are grave and serious discoveries on my part. I am not an attorney, yet I understand that the president can be brought before Congress on serious charges of obstruction of justice and high crimes and misdemeanors, when by his conduct he intended to hinder the ongoing investigation of the special counsel, and additionally by his continued public campaign, may have thwarted the cases brought before the grand jury by interfering directly in witness testimony. Very serious, pages 156 through 163. The impeachment process was not to have been treated lightly. It was serious crimes the president had committed, and 14 trials hung in the balance. Mueller continues to lay out his legal case on page 163, directing us to 18 U.S.C. Section 1503. It generally prohibits conduct that interferes with the administration of justice. Section 1512C2 in federal obstruction of justice statutes captures corrupt conduct other than document obstruction that has the natural tendency to obstruct contemplated as well as pending proceedings. The law overlaps with 1503, which is pending grand jury and judicial proceedings, and 1505, pending administrative and congressional proceedings. In 1519, the law states, the witness must merely have the intent to obstruct justice, even if it's unsuccessful. And I think we can see that Trump did indeed attempt several times to obstruct justice. Sometimes he wasn't successful, but that doesn't matter. It was a high crime and a misdemeanor. Congress doesn't need to prove a link between intent and content, as long as the conduct was seen to be directed at skewing the official proceedings when charging. Mueller recommends noting the overlap between sections 1503, 1505, and 1519, meaning that section 1512C2 may be broadly interpreted. He continues by stating that Congress enacted 1512C2 as part of the Sarbanes-Oxley Act of 2002 under George W. Bush. Tampering with a record or otherwise impeding an official proceeding, Section 1512C, was added by the Senate to close loopholes, such as document shredding. Both houses of Congress memorialize the unambiguous statutory text. Therefore, both houses of Congress memorialize 1512C2, prohibiting corruptly obstructing, influencing, or impeding any official proceeding or attempting to do so. The Senate committee explained that the purpose of preventing an obstruction or miscarriage of justice cannot be fully carried out by a simple enumeration of the commonly prosecuted obstruction offenses. There must also be protection against the rare type of conduct that is the product of the inventive criminal mind, and which also thwarts justice. This was verbatim. It's disingenuous for any branch of government to call this investigation a witch hunt or partisan, since the law was written and ratified by both houses of Congress. Since the law was written and ratified by both houses of Congress in 2002 with a Republican majority. The Supreme Court has deferred to Congress in defining crimes and giving fair warning of what a criminal statute prohibits. However, Congress's interpretation supersedes all others because it assumes the person had the intent to obstruct justice in mind. Justice Scalia agreed with Congress and the interpretation. It denotes an act by an official that is inappropriate or inconsistent with official duty, giving them the advantage and influences the rights of others. I paraphrase page 166. And I will stop here and continue on item 104 at another reading. But as you can see, obstruction of justice is very, very serious and does come under the heading of high crimes and misdemeanors. This is not trivial when you obstruct justice, whether you shred documents, whether you have in effect tampered with witnesses going before the grand jury, whether you're asking your own people to stop a special counsel's investigation. You are indeed obstructing justice. And Trump did that. Nothing happened in Congress, but that doesn't mean that the president wasn't guilty. So, we will continue on item number 104. Thank you for listening.